Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So today we are from group 6 BBRMT wanted to present our task 1 and task 2. So for task 1 we are choosing motorcycle insurance from Etika to complete our task. And then this is our group members. So this is the content for our task 1. The first one, insurer and insured. The second one, type of insurance. The third one, risk insured. And the fourth one, premium. So now let me introduce myself. My name is Nurul Hanisah Binti Jamili and my matric numbers is 061551. So now let's move to the next slide. Okay, let's go to Etika Insurance Company. Etika Company is a major player which is major insurance in Southeast Asia, offering insurance in Malaysia, Singapore and beyond. Secondly, the Etika names itself rebranded from Malaysia International Insurance in 1965. Okay, now let's move to the motorcycle insurance. Generally, motorcycle insurance offering a variety of plans to protect riders and their bikes from any unexpected event such as accident, fire, theft and third-party liability. In terms of Etika Company, they are providing coverage for diverse roads, which is whether you are a city commuter or a countryside explorer, everyone can enjoy or purchasing motorcycle insurance to protect their loved bikes. Okay, now we are talking about insurer and insured. Firstly, insurer. Insurer is the Etika Company itself, which is the expert management of financial risk associated with motorcycle insurance claims. The company that provide financial. And then insurer also secure income through premium collection while expanding their customer base, which means the insurer get the income from the client's premium. And then insurer also offer competitive plans. As I mentioned before, Etika providing various type of plans to protect clients' motorcycle. The second one is insured. Insured, which means motorcycle owner or client. So, motorcycle owner are the one who are being protected by Etika. Motorcycle insured normally buying or purchasing the premium to get a guaranteed financial support in case of unfortunate event. And then insured often select the right plans from various options. Insured also transparency and trust when they are dealing with the insurer to get their underwriting for their policy. Okay, let's move to the next slide, which is the type of insurance. Of course, Etika providing few type of insurance that can cover unexpected event in riding motorcycle. So, the first one is for private use. It is obviously for everyday tasks, right? For errands, gateway and occasional business meeting. Everyday cover but not for regular work travel. The second one is commercial use. Commercial, also known as business. So this is cover for business purpose such as deliveries, repairs and food service. The third one is motorcycle trade. Motorcycle trade insurance is crafted to suit the specific needs of different industry segments. Protect dealerships and repair shop from showroom activities, accidents, theft and repair issue. Of course, it is custom for different industry segment. The last one is motorcycle used for hire, rental bike protection against damage, theft and third-party liability. Clear rental agreements and rider screening recommended.
Assalamualaikum warahmatullahi wabarakatuh. My name is Shakir bin Shaffie. I will present about risk insurance covered by Etika. In Section A, loss or damage to own motorcycle. Etika Section A in motorcycle coverage serve as lawyer protector against a variety of problems that may strike valuable machines. It is important safeguard providing financial assistance when disaster strikes and repair or replacement are required. Furthermore, fire explosion or lightning and Etika cover fire damage whereby is the waiting of an engine problem. After that, risk insurer is not covered by Etika in Section 8. This includes the following wear and tear inclusion. Routine wear and tear is not covered, such as worn tire and faulty brakes. Insurance protects against unexpected events rather than progressive degradation over time. Besides that, accidental versus mechanical breakdown. If engine fail, brake fail, or another mechanical issue cause a collision, insurance companies consider such situation to be obligation to control through regular maintenance rather than something they cover. Okay, next for the section B, Etika motorcycle policy shift the focus to protecting others and their property in case involved in an accident. There has two crucial aspects, and what is covered is liability third party. Next section B provide financial protection against medical bill, lost income, and legal fees incurred as a result of such event. Second, third-party property damage, and section B cover the cost of repairing or replacing property damage while riding. It protects from the financial consequence of destroying the property of others. Risk insurance does not cover by Etika in section B. It is intentional acts causing harm to other of their property is uncovered. Reckless riding or illegal activities also void protection under section B. Second, mechanical breakdown and tears. If motorcycle malfunction or worn out parts leads to an accident, the resulting third-party damage is not covered. Number 4. Premium. Factor influencing premium motorcycle insurance by Etika. By its value, the higher the value of motorcycle, the higher premium will be. This is because Etika needs to cover the cost of replacing bike if installed or damaged beyond repair. Riding experience. If a new rider likely pay a higher premium than an experienced rider. This is because new riders are statistically more likely to be involved in accidents. As younger riders also tend to pay higher premiums than older riders. This is because younger riders are generally less experienced and more likely to take risks. Next is a claim history. If you have made any claims on motorcycle insurance in the past, like pay a higher premium in the future. This is because considered a higher risk by Etika. For the last one is location. If live in an area with a lot of traffic, we likely pay a higher premium. This is because motorcycle is more likely to be damaged in these areas. Conclusion. Etika motorcycle insurance offers a range of configurable and all-inclusive plans to satisfy the diverse needs of riders, whether use motorbike for professional purpose, to go through rural areas or through cities. Etika has a policy that will provide with financial security. Remember that getting motorcycle insurance is an investment in financial stability and safety.
Assalamualaikum. My name is Binti Sulaiman. My matrix number is 061446. I'm going to talk about facts of the case and judgment. Facts of the case. This is a civil case between Etika General Takaful Berhad, plaintiff, against Fatimah Binti Adam, who is personal representative, who is defendant. In this case, plaintiff Etika General Takaful Berhad, an insurance company, issued the defendant a certificate for death and disability coverage from Etika General Takaful Berhad in 2019. A claim for death and disability made by the defendant, the estate representative of the policyholder who passed away, Fatimah Binti Adam, was denied by Etika. They claimed that Fatimah's failure to disclose a pre-existing medical condition on her application had a major impact on their decision to provide the Takaful certificate, which served as the foundation for their justification. According to the theory, a substantial non-disclosure might render a contract unenforceable if the applicant had concealed facts that would have likely affected insurers' decision to take the risk or impose a different premium. It was up to the courts to decide if Fatimah's unreported medical condition qualified for this exception. Etika argued that the claim was denied because the undisclosed disease had significant consequences on their risk assessment. In response, the estate representative argued that the condition had no bearing on the insured risk, and therefore the contract should remain enforceable. The interpretation of materiality in the particular setting of the case and the Takaful sector was the focus of this judicial debate. The High Court ruled with Etika in 2021, declaring that the insurance contract and non-disclosure material were void. This example emphasizes how important it is to provide accurate and thorough disclosure in insurance and Takaful applications, as even little errors can lead to the denial of a claim.
Assalamualaikum. My name is Nurfazreen Ilyana Binti Omar with matric number 059714. I will explain about the issue of this case. The main issue was whether the individual who purchased the policy renewal purposefully neglected to report the insured debt and whether the insurer was entitled to a declaration that the policy was null and invalid. The issue also addressed the interpretation of Section 129 and Schedule 9 of the Financial Service Act 2013, which regulate pre-contractual disclosure and representation obligation in consumer insurance contract. Next, the whole of this case is the court determined that there could be no legitimate insurance contract in favor of the insured at the time the accident occurred. The plaintiff was entitled to the declaration requested, and the plaintiff was required to pay the premium for the two policies to the purchaser. The court further stated that Section 129 and Schedule 9 of the Financial Service Act 2013 did not apply in a case where the insurance contract never exists in reality or in law, or was void initially. The court read paragraph 5 of Schedule 9 of the Financial Service Act 2013 and determined that failing to ask the potential insured to answer pre-qualification questions did not automatically result in the waiving of the insured disclosure requirement under the duty of utmost good faith. The court also stated that the insured, Fatimah Binti Adam, who died on June 23, 2016, lacked the competence to renew her insurance with the plaintiff. As a result, the policy in her name was renewed twice without any formal insurance contract in existence. The court ordered the plaintiff to pay the premium for the two policies to the purchaser, and the decision left the third and fourth defendant with no recourse against the plaintiff for their indemnification claim. Overall, the court held that the plaintiff had the right to declare the insurance null and invalid, and that the plaintiff was required to pay the premium for the two policies to the individual who purchased them. The court further clarified the interpretation of paragraph 5 of Schedule 9 of the Financial Service Act 2013 and concluded that it had no relevance in this case where the insurance contract never came into existence in reality or in law or was void initially.
The courts determined that as a matter of law, there could have been no valid insurance contract in the dead insured's favor at the time of the accident. In addition to being entitled to the declarations it requested, the plaintiff was also required to refund the initial buyer of the two insurance for their premiums. In a situation where the insurance contract was void from the beginning or never actually came into existence, the court decided that Schedule 9 and Section 129 of the Financial Service Act 2013 applied. According to the court's decision regarding Schedule 9, Paragraph 5 of the Financial Service Act 2013, the insured's disclosure obligations under the requirement of utmost good faith would not automatically be waived if the potential insured was not asked to respond to the pre-qualification questions. The insured Fatimah Binti Adam, who passed away on June 23, 2016, was considered incapable of entering into a policy renewal with the plaintiff, according to the court's judgment. As a result, the policy in her name was repeatedly renewed without a legitimate insurance contract in existence. The courts ordered the plaintiff to pay the premiums for the two policies to the purchaser, and its decision left the third and fourth defendants with no recourse against the plaintiff for their compensation claims. In short, the court's decision considered the insurance null and void, and the plaintiff was ordered to pay the premiums for the two policies to the purchasers. The court further clarified the interpretation of Paragraph 5 of Schedule 9 of the Financial Service Act 2013 and concluded that it had no effect in a scenario where the insurance contract never existed in reality or was void.
Assalamualaikum. My name is Sheikh Mahadhir bin Feshal and my metric number is 067566. So I was explaining about the parties of arguments based on the fact of case. So let's see one on one side, which Etika Jinta Takaful stressed the critically of complete disclosure in insurance deals. They argued that undisclosed information, notably Fatimah's hidden health issues, significantly influenced their risk assessment, impacting pricing and coverage decision. Conversely, the estate of Fatimah Binti Adam, which is defendant, argued that the undisclosed health issue didn't relate to the covered risk within the Takaful agreement. They contested the idea that this undisclosed issue substantially affected the insurer decision-making process. Both sides are fiercely defended their position, with Etika stressing the necessity of full disclosure for accurate risk assessment, while Fatimah Binti Adam estate emphasized the lack of impact of the undisclosed health issues on the insured risk. Last one, this case demonstrates the importance of transparency in insurance agreement and the weight of undisclosed information on their enforceability. It highlights the significance of full and honest disclosure and revealing how even seemingly unrelated details can impact the validity of insurance contracts. Alright, next, let's see the commenter. So about the commenter, I would like to suggest about the complexity of the case which Etika General Takaful Berhad versus the person in charge of Fatimah Binti Adam. So this is legal tussle navigates the intricate details of Takaful contracts, exploring the legal ramification of incomplete disclosure. So Fatimah Binti Adam held a Takaful certificate from Etika General Takaful Berhad, providing all necessary details during its issuance. However, Etika rejected her claim for death and disability due to her undisclosed illness, sparking a debate about how this omission influenced the insurer coverage decision-making process. From Etika perspective, the principle of non-disclosure of critical information played a significant role. So they argued that undisclosed health issue influenced their risk assessment, potentially altering choices regarding insurance cost and coverage adjustment. So on the flip side, the estate contended that Fatimah undisclosed health issue wasn't related to the cover risk within the insurance plan. So the court ultimately sided with Etika and invalidating the insurance deal due to the absence of crucial information. This ruling underlining the paramount importance of accurate and comprehensive disclosure in insurance and Takaful agreement.
That is all from us. Thank you.